Good evening, everybody. Welcome to another IBIL packed house. I think it's a pity that we don't sell the tickets for a lot more, then even more people would come. The Supreme Court has spoken with somewhat mixed voices. This panel is going to tell us what they think of it and where patent law should go next. There are three subjects, but we'll probably concentrate on the two big ones. And I'm going to sit here as question master. Let us take plausibility first. Let me start with Germany. Matthias, where do you reckon on the Supreme Court decision on plausibility?
Yeah, that's a tough question, because usually as an infringement judge I'm not dealing with these kinds of complicated problems. The only thing I could do to prepare for the evening today was to read the Federal Patent Court judgment on the German part of the European patent we are talking about tonight. And they had also the problem of plausibility, but only as an auxiliary request. So the first request was, please kill the patent because it's not new. Second, please kill the patent because it's not inventive. And also only the third attack was on plausibility. So as the Federal Court, Patent Court in Germany found that it was not inventive, they only touched on plausibility, I think, with 3 sentences. And it's not so much knowledge to suck out of these. The discussion before we had when we gathered to come here was that the notion is that it might be the UK test we have at the moment might be too harsh.
Yes, that's one of them.
I would agree.
Matthias has prepared some slides, which if we went through the lot, would be squeezing things either too much or we'd all be here too late. But they're going to be put up on the UCL website. And Edgar has also prepared some slides from Holland. So a possible view is that the majority have put the test for plausibility too high. What would the Dutch view be?
I think it is on the high side. Let's put it like that. I've already said up front that it's for me it was a hard judgment to actually get to the end of. It's not easy to grasp.
Does anybody else agree with that?
Not easy to grasp what exactly they found. As far as I understand it, and I think you have to read that for the other judges, is that the majority opinion is that there should be prima facie evidence.
Yes.
That might be a little higher than in Holland is usual.
I think, do you not have a burden of proof the other way around? It's on the opponent to say prove it's implausible.
Well, that's I think is logical, because the opponent is assessing that it's an invalid patent, so he should also give the proof to that assertion. So that's a mere matter of law. There's a judgment on that fairly about a year ago. Leo Farm, that's in my slides, that apparently I made a little bit for nothing.
No, you didn't.
No.
Well, you never asked.
That sounds like a little bit, no. I remember, what was it, Life of Brian. Are there any women here? No. Okay, sorry. That was the stoning of Christ, for those of you who don't remember.
We do.
So I think it's a little too high, and yes, there is the burden of proof in principle is on the person alleging that the patent is invalid to give proof why that it's implausible. So especially in cases where, for instance, later on it turns out that it's implausible that that effect actually exists, then that comes into play.
How would this work out in Holland then? If a man comes along and says, well, I have a hunch that this compound, let's assume for the moment it's a new compound altogether, will cure this disease. So what I do is I claim this compound. If the burden of proof lies on the defendant to prove that that's implausible, he's got nothing to work on, is he? And supposing it does work.
It depends on how you look at it. The plausibility also, of course, extends to breadth of claims. And there you can more easily understand that if it's implausible over the breadth of the claim, then at least the person saying that it's implausible that a certain effect is there.
That's why I chose a single compound. That's why I chose a single compound to avoid breadth of claim.
But you didn't mention whether it was for a certain effect. But let's suppose that you're saying that the effect, or at least the infringer is asserting that the effect is implausible. Can you hear me?
Yeah, just get closer to
Better?
it.
Okay. Like this? Yeah, it is a little. Yours seems to be doing better. Or are you just more? Do you shout better?
Right.
Can you understand? Can you hear what I'm saying right now? Not still. Like this. Does this work? Well, is it my voice? Maybe it's the pitch. Or the pith and marrow. No, sorry. So about plausibility of a certain effect, I think it's reasonable to ask at least to give for the infringer to say, okay, why is it implausible, this effect? Why do you think that it doesn't happen? If it's one compound, it can also be a discussion about whether that effect, for instance, improved use or improved safety, that does in fact occur for that compound.
Lenny, what do you make of the decision on plausibility?
I've got a fair amount to say about the decision, but I'd first like to ask Edgar if he says that it should be for a person challenging the patent to prove that it is not plausible. Does Dutch law also require a person who says that there was no inventive step to prove that there was nothing inventive about it? Or does it require him to prove that it's not new?
Well, in fact, yes. The answer to that simply put is that it's the person asserting that the patent is invalid under Dutch law has also the burden of proof of giving proof for that assertion. So if he says it's invalid, he is the one who obviously has to come up with documents saying that and why it's not an inventive patent. And it goes from there. And also if it's, for instance, saying prior use, it's obviously the person stating that it's prior use who has to prove that there is public prior use, and it's in his realm to prove.
Isn't that the English position too? If you want to say the patent's obvious, you must show it obvious.
Do you want me to say some more about it? Well, on the question of sufficiency, it seems to me there's a range of options which is open to the court. And at one extreme, you can say the specification is sufficient only if it enables you to make the product or perform the process. There's no reason for thinking that it'll be able to do so. And if it turns out not to, well, it'll have been a waste of money for the patentee to apply, but no harm will have been done. Now, the objection to that, and the objection made by the minority, and I thought rightly so, was that it will enable someone who has made no contribution to human knowledge to stake out a monopoly, like a miner's claim in some area of research, with a view then afterwards to do the digging to discover whether he struck gold or not. And that seems to be not what the patent system is about. And at the other end of the range, you can require that the specification provide experimental evidence to show that it works. But for many pharmaceuticals, that would be very difficult to satisfy. You can do it in vitro, you can feed it to rats, but only clinical trials will show whether it does work or not. And to refuse a patent until it can be shown that the effect can be proved would be to block potentially valuable lines of research, particularly when it's difficult to get funding for research. Unless you won't be able to get funding unless there's some way in which you can prevent competitors from nipping ahead of the inventor. Now, that need for compromise seemed to me very similar, although this wasn't mentioned in the case, to the problem which faced the Supreme Court a few years ago in deciding when an invention could be said to be of industrial application. The problem in that case was, there you have a new product, but is it of industrial application? And they said, well, at what level of generality do you have to specify the potential application of a new pharmaceutical product? Do you have to be able to identify the disease, or is it enough to specify a fairly broad class of diseases? Again, the question which came to in that one was, at what point in your research in the potential uses of a new product or a new use of an old product, can you stake out your monopoly protection under cover of which you can then raise funds to carry out further research? And although the court in this case was divided 3-2, I thought there was very little between them. I mean, the majority said you must demonstrate in the light of common general knowledge that the claimed therapeutic effect is plausible. And he says it may be rendered plausible by the specification showing that something is worth trying for a reason, not just because there was an abstract possibility it might work, but because reasonable scientific grounds were disclosed expecting it might work. It might well work. And that's the difference, he said, between speculation and a contribution to the art. Now, that seemed to me very persuasive. And Lord Hodge, for the minority, said he agreed the specification must disclose some scientific reason for thinking that it might well have the claimed therapeutic effect. And he said, but what he objected to, he said, was that he mustn't have to demonstrate a prima facie case for a therapeutic effect. And I must say, I can't find the mention of a prima facie case or any such requirement in what Lord Sumption says. It looks to me it wasn't so much a difference in principle as a difference over whether one should have disturbed the finding of the judge, Mr. Justice Arnold, that they'd crossed the necessary borderline. The majority thought it was a question of degree which they should not interfere with, and Lord Sumption and his supporters thought that even taking Mr. Justice Arnold's findings of fact at face value, they didn't justify the conclusion that there was some plausible reason for thinking it would work. But as an exposition of the law, I must say I found Lord Sumption's judgment entirely convincing.
Ursula, where stands the Boards of Appeal, or where you used to be?
Thank you very much for, first of all, having invited me here to such an auditorium. I'm impressed very much. Actually, a good question, and I can't answer this question straight away because so far the decisions of the Boards of Appeal, which I'm very grateful that the Supreme Court did talk about them and did analyze them, and I think they did it well. Perhaps they left out the one or the other, which might not fit that well into the concept. But this brings me to the point that we now have to think about what is the state of the art of the decisions of the Board of Appeal, and which message can they then possibly take from this decision now from your Supreme Court. And I think they did a very good job in going through the starting point for this term plausibility. I mean, plausibility, what is that? That's, they argued, and they said it in point 37 very nicely. Plausibility is not a term of art, and its contents is inevitably influenced by the legal context. Of course, just to prepare here this evening, I had a look into the dictionaries, and if you look for synonymous or synonyms for the word plausibility, you end up with probability or likeliness, and likely, probable, and so on. And these are, of course, terms which are for legal certainty in the patent law not very, very good. And so the plausibility problem started actually with this decision 1329 out of 04. John Hopkins' decision there, this expression plausibility was born by my colleague in the second Biotech board. And one has to say that the idea to approach now the problem with, let's now call it, speculative inventions in the area of medicine, second medical use inventions, that's the whole business where we are and which causes the problems. The pendulum was so much apparently in this area, which was not before my board because we separated the IPC classes, but the pendulum was so much in let's call it what a nice expression invented here now, the armchair inventions. It was the pendulum on that side that the board really thought they have to go back to something where one at least has something at hand which can help to come to a fair judgment. And in the light of this, and then we have the development of quite a number of cases which were interpreted and analyzed very nicely in the judgment. We came to a conclusion which I would consider to be more or less the message of now your Supreme Court. And that there are two decisions which might not fit into this pattern, but perhaps one can do something with this and with this board. That perhaps the pendulum goes back into a reasonable middle requirement, middle term of how we can interpret this term plausible, which is a wobbling and of course an elusive term which you never will get really. It will not be able really to get a very clear message what is meant with this. But where we now are, I think we are more or less on the same level in the Boards of Appeal, like now here in UK.
Now, Matt, what are you going to teach the students about this?
It's a very good question, one that I probably don't have an answer to just yet. I mean, I think at this point in time, what we're necessarily looking at will be something that has a degree of speculation around it anyway, because we have to remember that this is in the context of a second medical use claim, and therefore we're not looking just for the fundamental efficacy of a particular product. We're looking for the efficacy on this use. And from the point of view of the time at which the proof for that arises, then obviously the proof will necessarily come at a later point when we've got the full clinical trial. So there will be a degree of speculation around this particular product and its efficacy anyway. And you've got to have a slightly higher standard, I think, where we're dealing with second use claims than where we're dealing with pharmaceuticals in the first place. And one of the points that I'll be making later on, hopefully, is that really when we're thinking about second medical uses, this is a crippled form of claim anyway, in the sense of the Swiss form. In which case, if we're looking at it from that perspective slightly out of the corner of our eye perhaps, then that must be reflected across the board. So not just for infringement purposes, but also arguably a slightly higher standard for sufficiency. But there we go.
And I'll put this to all of you. Would we be better off if we took away the restriction you can't patent methods of medical treatment, or would the problem still be there? I mean, they don't have this problem in America. They have other problems, but they don't have this one. So would we be better off if we got rid of that restriction in the EPC? What do you think?
I don't think so.
I suppose you still need some type of incentive for research to be done on new therapeutic indications. Otherwise, that might stop.
Yeah.
And it's still important because one of the advantages, of course, being that it's already usually it's well-researched product, so it's already safe. Everybody, it's been in use for a while, and then it can be very helpful if they find new use for that good thing.
The board figures are something like this. A new medicine altogether cost about $1.5 billion, 12 to 15 years. A new use for an old medicine, about a quarter of that, and a much shorter period for clinical testing. And as far as doctors are concerned, a new use for an old medicine is just the same as a new medicine. So you're getting 4 for the price of 1. And one would think that it'd be nice if somehow the law encouraged that kind of research.
Well, maybe just one comment. I'm not sure about the background of this invention, but you could argue perhaps in this case that this product was first used for epilepsy, as far as I remember, and that it might be just very plain monitoring of epileptic patients that they find out that it now also works against pain. So that might not be that big an invention after all, if you look at it from a monetary invention, a monetary value in the sense of how much do you invest to finding this particular claim. That probably this one might not be the biggest, but there are others out there that for sure wouldn't have existed if not for the patent system.
Well now, does anybody want to add anything to plausibility before I put it out for questions? Okay, let's have a few questions. Then we're going to do infringement in the second half. Right, we've got, has anybody got a mic? Okay, we've got plenty of mics down here. Some of them don't work. But shout.
I think it's a really interesting issue, and clearly discussing about the nature of the invention and the claim category. Because I think the question on the mind of many people I've been discussing here is to what extent this decision is relevant to product claims. Is this a question of the claim category that the claim is in, or is it a question of whether a development invention or already existing pharmaceutical? And I think there's potentially some confusion around the fact that the second medical use format. To your point, Jacob, could it be possible to reformulate many of these claims as product claims, and it would still be a downstream invention? So is there a different standard based on the claim category, or is it the nature of the invention relative to prior art? And I think for me what was interesting in relation to the EPO case law, that lots of the product case law was relied upon by the Supreme Court and the question is, can you reverse engineer this decision and say it was equally applicable to product claims?
Right, question is this just transferable straight over, as far as plausibility is concerned, to new product claims, as opposed to second medical use claims in this rather metaphysical kind of claim? Lenny, what do you reckon?
When you have a new, as I understand it, when you have a new product claim, sufficiency is satisfied by being able to make the product. And the point which has been raised at the back there, and which is a very good point, transfers itself to the question of industrial application. What's the use of this new product? To what extent have you got to show that it has a given use?
So you would say that really, if it's a new product, it's HGS standard, and which is...
If it's a new product, it'll pass the sufficiency test.
Yes.
And then it becomes the HGS question.
Yes.
Is it an industrial application?
Yes, because we had a second follow-up decision in the Court of Appeal to deal with sufficiency. If you remember in HGS, they left over sufficiency because it hadn't been argued, and we had to deal with it in the Court of Appeal. We found it very straightforward. Well, if it's capable of industrial application and it was agreed you could make the stuff, the only point was, well, what for? To which the answer was, it didn't matter.
Maybe I can add something. I think it also depends on what sets this invention out, what makes it inventive. In Holland, usually plausibility is something that comes up in inventive step. So you're claiming a certain effect. That can be for a first product too, for a first invention, for a first indication just as well. You have the Agrivo decision, for instance, for breadth of claim. So if you're claiming a certain effect, and that's what makes the contribution to the art, and not so much finding a certain product, but giving it an effect, then I suppose the plausibility test just as well applies.
Matthias, do you think this is much the same, whether it's product, new product, or a second medical use type of product?
My understanding of the plausibility test is that you only have to apply it in second medical use cases, because if you just apply the test, is it workable according to the information provided in the description? Yes, it's workable. You know the ingredient and how to make this ingredient because it's a known ingredient. And in the patent claim, you are instructed to apply it to treatment of pain, in our example. So it's workable, full stop. And they figured out that this might not be enough as a test in the case of second medical use, because a patent applicant could just sit in the armchair and apply for a bunch of patents he could think of, doing nothing else in the clinic or somewhere. Yeah? So they figured out this test to apply for these kinds of claims means that you don't apply it to other claim categories.
Why not? Because supposing I sit in my armchair and I think of a new chemical compound and say, right, well, I say that this will work on this particular disease. It's a new compound claim.
Yeah, then I think we do the same at the Dutch, that we deal with this problem in the inventive step category.
Okay.
So it's no invention is just guessing.
No invention, just guessing. Because one of the beauties of the EPC, and indeed all patent laws, is you never really define what an invention is.
Mind you, you can also have plausibility questions about prior art or even the priority document.
Yes.
So even prior art can have the question raised, is what's said there, has that been made plausible? And as such, is that therefore a prior art that's sufficiently damaging or not?
Especially if it's only an application, which never made it to a patent.
Yeah.
Because it's not plausible.
Matt, do you see this as transferable equally between second medical use and new compound cases?
No. I mean, I think in terms of what you're saying, you have to show for a second medical use case that there is a degree of plausibility that it will treat what you're claiming that it treats. In which case, we stay with that. I wouldn't say you have to show that for a medical claim in general for a new pharmaceutical. It won't be the same assessment. Because you're not claiming novelty necessarily in relation to... The only thing, if you're thinking about a second medical use claim, as far as I'm concerned, you're sashimi slicing so that then you're getting closer and closer to what's already been disclosed. So there's a new bit of information that's been given, which is the new use. And so you must have to show that it has some degree of plausibility for that new use, or else you're just chopping something up for the sake of it.
Why you have a compound patent where you take the whole, all compounds that could exist, and you're slicing down into small group, you were saying it's useful for some particular purpose. Surely you need to be able to show that that purpose is useful to have contributed to the world somehow, right?
Well, degree of utility that might exist in the creation of something new. I mean, to say that it has, I'm not necessarily sure that you would need to pinpoint, or I can't see any real reason why you'd need to pinpoint the exact benefit that you're saying this contributes, if it contributes a benefit by creating it and producing it. But I can't go further than that at the moment. Would need to sit and think.
I have to say, when I came to the bar, which was sort of just before chemistry started, the pharmaceutical patents really said very, very little indeed about what this stuff was good for, and still less about why they thought it was good for it. They were very, very simple patents. You might like to go and look at 1969 reports of patent cases, the phenothiazine patent. That was a medicine which now, of course, is thoroughly banned, as so often.
How different it is nowadays, where they put almost everything in the application. A lot of boilerplate texts like it's better or it's safer and so on and so forth.
Yes.
And then later on, hopefully, they find the proof for that. That you can see too nowadays.
Yes, you do. There was the patent, which I described as the kind of patent that gives the patent system a bad name. There were 3 patents for taken out on the same day for 3 crystalline forms, and each of them was said to be exceptionally good, without any detail. Yes, Alistair.
In a follow-up on that,
Can we not get a mic somehow?
There's nobody to hand them.
No. Is this working? Come and get it. And hold it close.
I was going to follow up on Matt's argument. Years and years ago, I wrote a moot problem which concerned a copper bracelet which was alleged to have a therapeutic effect by reducing arthritis. And the idea was, well, you could clearly make it, so why, under the European Patent Convention, couldn't you get a patent for it? Since then, the EPO has demonstrated that actually they can use inventive step, as we heard, as a mechanism for getting around that. And my recollection is that there was quite a stage with HIV inventions where effectively they were rejected on the grounds that actually nobody had demonstrated a plausible basis for saying that this compound had any effect on HIV at all. It seems to me slightly ironic that since the Warner-Lambert decisions have come out, then the arguments of sufficiency have spread into the mechanical area, so as a squeeze in relation to inventive step as against sufficiency. And actually, perhaps the idea of plausibility is really what one needs to make it clear that there isn't a squeeze between inventive step and sufficiency, because sufficiency is a much lower threshold than inventive step is. And therefore, one will see it creeping back into inventions relating to anything from mechanical apparatus, where there is a significant degree of uncertainty as to the underlying principle of why it operates.
And that reminds me of a case, it's the only case I ever had of an invention, it's a mechanical invention, in vast use, it's reinforced earth, where when you're told what the invention is, you don't believe it works. But it does. And that raises another question. In the old law, you could even have a good patent for something where it was founded on a wrong theory. And I think that must still be the law. Do you agree it is still the law? Maybe, was it?
Yeah.
Do you agree, Lenny, it's still good law that if you have a wrong theory in the patent, nonetheless, if it works, it's okay?
If it works, yeah.
Well, if the wrong theory makes, people say, oh, that's obviously wrong, you know, use phlogiston or something or other. Doesn't it become implausible? Doesn't it become implausible?
Well, if it's clearly wrong, then it's not plausible.
But if it works, that's the point. The theory for it, why it should work is wrong, but it does work.
Yeah, but the test if it's information in the description which makes it plausible, and the information in the description is wrong,
Yeah,
unplausible,
yeah, exactly. Implausible.
implausible.
But, I'm sorry, but the question of
Too many negatives.
the question of plausibility can only arise when you don't yet know whether it works.
Yes.
So therefore, if it does work, it doesn't matter why it works.
Well, that's not true of second medical use patents, but it is true of first use patent.
Is a concrete example of the original patents on margarine. The theory as to why margarine tasted like butter was completely bonkers. But it did taste sort of like butter.
Hugh Laddie was very cross with me for allowing on the register, I can't believe it's not butter. But I still think I was right. Right, well, we've got to deal with infringement now. Otherwise, we're not going to get, we could go on with this for hours. Now then, infringement. I'm beginning with you, Matthias. Has the Supreme Court got German law right?
Yes. But maybe there are some points I'd like to highlight. So I assume you all read the judgment? No,
Yeah.
okay.
They're supposed to have done. So it's like our
You're
students.
supposed to.
Of course.
So the German situation has two eras, the era before and after Pemetrixate decision of the Federal Court of Justice. So before the decision, these kinds of claims, irrespective if it's a Swiss type claim or EPC 2000 claim, were treated to be a use claim, different from the UK approach. A use claim, and the claim language in the Swiss type for the preparation, blah, 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 was of no importance. So direct infringement would be the use of the product in respect to the patented indication and the purposefully preparing for this use is also regarded as use. So this is also an infringing. And of course, putting on the market these purposefully prepared products. Not direct infringing would have been the making the drug as such, or for the not patented use, or acts not sufficiently attributable to the product. And there we have some case law also cited in the decision of the Supreme Court, of the High Regional Court. So what happened was that the generic company is skinny labeled, so this is legal, but there were general announcements in the marketing materials or flyers or advertisements or indications given by salespeople that this skinny labeled drug could also be used in the patented indication. And these were found not to be infringing at least not directly infringing the patent, as not sufficiently attributable to the product, as is the label of the product, for example. The patent owner didn't go for indirect infringement, so the court didn't touch upon that. And then we had our Pemetrixate case, where they said, one second, that pharmaceutical use patents and manufacturing use claims relate to the suitability of an already known substance for specific therapeutic use, and therefore ultimately to a property which is inherent to the substance itself. And therefore, these claims both grant a purpose-limited substance protection. So there was a shift between use claim to product claim understanding of the same claim language. And I think the consideration behind this is that with the EPC 2000, the problem which gave rise to the Swiss-type claim language had been cared for. And then we had these Swiss-type claims, patents, living, and at the same time, these EPC 2000 claim patents, living, both disclosing the same invention. So why should you treat them differently? And the decision, Pemetrixate, was a nullity decision, but we have strong indications by the courts and by scholars that it also should be applied to the infringement side, meaning that these kinds of claims, irrespective of the exact claim language, should be treated as substance claims. And this renders a lot of problems void we had before. And let's go back to the Pregabalin, the German Pregabalin case. So the Pregabalin case decided by the regional court in Hamburg in 2015, so before Pemetrixate, they dealt about the skinny label product of Hexal, though they labeled Pregabalin for the treatment of anxiety disorder, blah, blah, blah. But the defendant entered into a rebate agreement with a health insurer, providing Pregabalin for whatever use they found appropriate. So the rebate agreement was silent on the exact use. And this was found to be indirect patent infringement by the Hamburg court, but it should have been direct infringement, as we now know. But at least it's an infringement. And I think, if I got it right, the Supreme Court decision, they would think this is not an infringement, at least the majority. And if this is correct from the English point of view, I wondered if you have the concept of unfair enrichment, and if the precondition is that you have a tort, or is it the same as in Germany, where a precondition could also be that it's not a tort, but anyhow it's unjust?
Well, I don't think we do have a sort of general unjust enrichment. We've had much discussion about it. We do have unjust enrichment, but it's much more confined. And all you're going for, if you are going for unjust enrichment, is the profits made by the generic company. Presumably, the extra profits.
By the defendant.
By the defendant.
Whoever is the defendant.
It'll be the generic company.
Yeah, it could also be the health insurer.
Or it could be the health insurer. But anyway, it's the profit. It's a much smaller profit than the patentee's loss.
That's sure, but it's something.
Edgar.
Well, yeah. A patent normally gives you a monopoly, so you shouldn't have to rely on unjust enrichment, I suppose. But, as far as the decision of the UK Supreme Court, the position in Holland is probably fair amount different. In Holland, it's much more patentee friendly in the sense that there we do the foreseeability test. So an objectified foreseeability that the product is going to be used for that purpose. And that then is in principle enough. And that in turn, if that's proved, then the infringer, the generic company, mostly, will have to do take all reasonable steps to stay away from using the patented indication.
But if he knows it's going to happen anyway, he doesn't have to take any steps. I mean, he just says, please don't do it or something. I mean, that was the Supreme Court objection to that, saying it's no good saying, as the Court of Appeals solution was, well, you must do your best to stop it happening, and if you have, you don't infringe.
Granted, I think it's for the generic company nowadays quite difficult in Holland to try and circumvent a second medical use patent, because it is they have to take all reasonable steps. And what is that? That creates obviously a lot of uncertainty for these generic manufacturers. On the other hand, you could also say that, in a sense, maybe in the UK, not sure about exactly in Germany, because I believe that there's also the foreseeability test in some cases. But in the UK, it might be that a second medical use patent is not worth a lot anymore. Because if you do a skinny label, that's it. In Holland, just a skinny label is not enough, as so says the Supreme Court.
What more can you do than a skinny label? I mean, Mr. Justice Arnold tried getting letters out to from the National Health Service saying, please don't do it. But I mean, what do you do in Holland? What extra things are they doing in Holland apart from a skinny label?
So far, on that particular issue, there's not that much jurisprudence. I think what you would be looking at is at least making sure that the whole supply chain does not encourage in any way usage for that particular indication. That's maybe one point that you can make, and also put it in your contracts. So make sure that the people that you do business with are not going to use it, or maybe even a chain of contracts.
I'm not following. The doctor prescribes it by its generic name. You can't stop the doctors doing that.
True.
And he doesn't put on the prescription what it's for, because you don't do that in Holland. I think only Denmark does that in Europe, maybe nobody else in the world.
There's talk about that should be introduced.
Yeah, but it isn't at the moment, so you can't make that happen. So what more can the generic company do than a skinny label?
Yeah, but they could add in the information about the drug that it should not be used for the patented indication, either because of patent law reasons or because of medicinal reasons. We have both cases heard in front of my court. The first one was the dexmedetomidine, which is also mentioned in the decision of the Supreme Court. But what they mentioned was the fast proceedings, the PI proceedings in Düsseldorf, and we had the main proceedings in Munich. And the defendant supplied dexmedetomidine, but in the information provided together with the medicine, they said, as the claim language asked for a loading dose, don't apply a loading dose. It's not healthy. Yeah. And we thought that this would be a safe harbor for them. Yeah. So that's what you could do. And of course, what Edgar said, you could include in any contracts. And in Germany, we have a lot of rebate agreements with health insurers and so on. Yeah. that they must not use the provided medicine for the patented use. That's at least something.
Yeah, because I remember a case where, I mean, sometimes it's not just leakage to a second indication, but the main indication nowadays is actually the second medical use.
Yeah.
I remember, I think it was the Sun Novartis case, where the first indication was Piaget's disease that only a couple of people have, and then the second indication was for osteoporosis. That was the big flood going in there, and then you can say, well, maybe they have to do a little bit more than just say put in a skinny label. Did you have to want to add something?
Yeah, well, what I thought was interesting was that both sides in the debate in the Supreme Court thought that Section 60 of the Patent Act was not an adequate tool for dealing with infringement of second medical use patents, and that they would each, on whichever way you went, you were to some extent taking a step in the dark as to what the consequences were going to be, and that it was possible, therefore, that you might require legislative intervention in order to deal with this. And Lord Briggs, I thought, put it very well when he said that you have to have a compromise between defining infringement so widely as to discourage generics from entering the market at all, and defining it so narrowly as to give little protection to the people who have the second medical use patent. You need a compromise between those two. And what the majority seemed to have gone for was, first of all, to have some coherence in the principle which they were laying down, that you didn't, for example, have chemists found to infringe on account of the state of mind of people whom they had no clue as to what they'd been thinking at the time. And also to have some degree of certainty about it. And I think that the position which they have produced is that it may need some legislative remedy, but although it may in the future need legislation, it's likely to be less productive of litigation than the alternative. It creates more certainty for the people who are dealing with it. You may or may not like that degree of certainty, but that's what they've devised.
Yeah, I mean, if it needs legislation, it would actually have to be another convention, an EPC 2020. That ain't going to happen, because I don't know whether they realise that those sections are based on the EPC, and we have to implement the EPC.
One of the problems that I have with this decision is that if you only look at the packaging or the label, there's so many ways of still encouraging that second use. And
At least if you produce more than anywhere in the world could be used for the old illness.
there seems to be something wrong.
Matt, where do you reckon on this?
I don't have too much of a problem, actually, with the result that this doesn't infringe. I mean, I've always maintained that in relation to second medical use patents, they were a clear extension of the convention in 1973 as it stood. There was provision that was made for a first use in medicine under the EPC 1973, but then that was something which was eroded by the second medical use decision of the Enlarged board. And so what you've got is effectively the grafting of a rudder and a propeller onto a bathtub and calling it a yacht. And that doesn't, yes, it might float, but it's not something which you would necessarily think is worthy of going out on the ocean. And so I think the fact that you've then got a narrow scope of protection for a second medical use claim is almost inevitable due to the fact that it appeared out of nowhere in the early 1980s. And it's been highlighted ever since that there were intractable problems. I mean, you said yourself that there were, in the Bristol-Myers Squibb and Baker-Norton case, that there were intractable problems with this claim format. Lord Hoffmann mentioned in the Merrill Dow case that there were problems to differentiating in second use cases, albeit in that instance, in the referring to the mobile case, between when it was used for one indication and another. And I think if we've got something which is designed first and foremost for an indication in a medical field, it's fairly easy to see when a non-medical use is being turned into a medical use. You've got to get marketing authorization and all sorts of other things. As soon as you then start saying, well, you can have a second use, you can have a dosage regime, you can have a treatment of a new group of patients, you can have a treatment of a new subgroup of patients, and you start sashimi slicing this even thinner, you're going to get problems with infringement. In which case, the only thing that's sensible is to say that you therefore get a narrow scope of protection, and you get subjective intention. And I think that's perfectly reasonable to say that if you intended to create it for a particular thing, then you should have the liability that attaches to that. Just saying that you've got to label it in that way is probably too narrow. But saying that there's an objective view, that you can look and say, effectively as the Court of Appeal did, that there will be some kind of leakage, and therefore you should be liable for that leakage, and maybe remedies can soak this up, seems to be a wholly implausible way of dealing with it.
I mean, we mustn't forget that actually this second use, not second medical use, actually works for a first medical use of an unknown compound. There's some perfectly good solid patents out there working on that basis. But of course there isn't a generic market for the first use.
Exactly.
Well,
The very fact they step in because of the second use,
Yes.
not because of the first use.
But this,
Yes, but they are infringers. No?
But they don't infringe.
no, I mean, I think this just demonstrates that the patent system is arguably not the tool to use to solve this particular problem. And if the patent system is not the tool, okay, fine, we don't yet have a tool that will solve this particular problem, and that's difficult, because there are undoubtedly noble aims that are being pursued here with investigating into the second use of known compounds. But maybe it's not the patent system that we need to look at for the solutions.
Does everybody else agree that the patent system has got its limitations and there's no patent solution that could work? You've got to think of another way of dealing with incentives for further uses for known medicines.
Well, one of the problems is, of course, the health system, that they want it as cheaply as possible. So everything is directed to making sure that the cheapest product, i.e. the one for the already unpatented indication, is the one that's sold. And if you are going to pay more for a product that has found a new use, that is, I suppose, the only solution that you have.
Yeah. Then do you see any way the patent system can be adjusted to make this work efficiently, or has it got to come some other way?
You mean, can it be adjusted judicially? In such
Judicially or indeed statute by statute?
Well, I've spent no time trying to sit down and draft legislation which will produce this result, and I think it's going to be extremely difficult.
I mean, we at UCL held a joint conference with Georgetown earlier in the year about second medical use. And the general consensus seemed to be that actually it's not the patent system that can really sort this. And the best ideas that were coming up were, first of all, that you should have the prescriptions indicating what the medicine is prescribed for. And secondly, there's got to be some arrangements with the payers, which will be, in this country, the NHS, but in many countries, insurance companies. And they've got to see that it maybe even be in their interest to pay extra for new uses, because they actually get a lot more people cured overall, not just in this case, but more generally. So they're getting better money, better value from their expenditure. But that's a very long haul to persuade people of that.
Well, I mean, one answer might be that if you have a second medical use, you don't get a patent for it. What you do get is you become joint owner or owner in common of the previous patent. And then whatever the royalties of that is divided according to the contribution you've each made.
I don't think that would work, because there may be the previous patent may be expired already or close to expiry.
Yeah, true.
Usually, if the first patent is still valid, then the product cannot come on the market at all.
Yeah,
Yeah.
yeah. These are always cases where the previous patent has expired or isn't
Yeah.
so
Yes,
close to
no,
it.
that's true.
Right, a few questions. I think Lord Hoffmann has to go in about 1 minute. We have arranged a magic carpet for him to get to where he's got to go to next. Any questions now, particularly directed at Lord Hoffmann? Yeah.
Lord Hoffmann, given that the topic of infringement was overturned, and given that it's an issue that divided their lordship, Lord Mansfield had to cast a casting vote, and it's probably clear to me that he did in fact cast that vote. Do you consider it's an issue that the lordship should have dealt with in the judgment at all?
As it turned out, well, no, I don't think so. I think that it was quite a good idea for them to set out all the arguments, and a subsequent court can read the arguments. And excuse me, I think the contributions of Lord Sumption on the one hand and Lord Briggs on the other are very, very valuable bits of writing. It will not be authority for anything in the future.
Lord Kitchen, take note. Right. Any others? Yeah.
Yeah, this is not perhaps a question, but more of an observation, and that is that there seems to be quite a lot of criticism of second medical use claims, whether they be Swiss claims or whether they be EPC 2000 claims. But it's only because we're discussing them in the context of the facts of this Pregabalin case. Because in my experience as a practitioner, most claims in the Swiss form or in the EPC 2000 form for a medical use are often for the first medical use.
Yeah, then it works.
The first authorised use of that drug, in which case they're stronger and no problem at all, because the only use the generic could ever make of it is the patented use. And quite often those claims are drafted in those forms because there is a piece of prior art out there which suggests an earlier use, which has never seen the light of day, never been authorised or in the clinic, or they're put in that form because they need to avoid a method of medical treatment objection. But the difficulties that arise from those claims aren't, what I'm saying is not universal necessarily. It's only because of a situation where you have earlier authorised uses, as you did in this case. But to me, it doesn't seem that they should be blanketly criticised as a claim, because most of them probably only ever are dealing with perhaps a use that never gets authorised or a use which is the first use. That was my only...
Yeah, we've got a recent example, the immunotherapy decision of Mr. Justice Burse, Henry Carr's last case as counsel. The use of DP1 for the manufacture of medicine for the treatment of cancer. Well, DP1 wasn't a known medicine. It was a reagent. And there wasn't a great generic industry, and they couldn't construct a skinny label because it would be no label at all. They would have a label with no known use on it. So I mean, that's working perfectly satisfactory. It's only when you've got an earlier medicine with a new use that these claims cause trouble, I think. Everybody agree with that?
Yeah.
So basically, we may be looking at a corner of the problem rather than and really, it's not such a big problem as everybody thinks it is. The magic carpet has arrived. Right, any more? Yes.
Do you think the decision has any relevance then for new form EPC 2000 claims? Because originally, when the proposal was in EPC 2000, it was that new form claims would mean exactly the same as Swiss form claims. And then the boards of appeal said, actually, we don't think they are. We think one
Lord
is a
Thompson got that wrong, didn't he?
Pardon?
Lord Thompson got that wrong when he said they no longer issue Swiss form claims, because they do.
Well, you can't get Swiss form claims at the moment.
Yes.
I mean, they're old, but they're going to be around for a significant, maybe at least another 10 years or longer.
Yeah, but
So-
they're actually still issuing them. If you ask for them, you can get one. There's a decision, something, okay, Texas, something or other, Texas University or something like that, which says they are not the same scope and you can have both.
well, not in the UK, but
Well, I see
believe
Ursula
that-
nodding.
I believe they have to be applied. I mean, it has to be pending before the implementation. There's
No, 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 no. They're saying they are not for the same scopes and you can have both. For a new application. Although,
So there's murmuring. There's murmuring.
that's murmuring.
I'm not. I think following Abbott Respiratory, then they said no to new applications concerning Swiss form claims.
Oh, I think it's another one.
If they're in the pipeline.
Anyway,
then
perhaps it's,
they can-
I mean, the difference between the two is still doesn't solve any of the problems we're talking about. Yeah.
So, so I had a question for Ursula and perhaps Edgar as well. Of course, if I have the misfortune to be unwell and need medical assistance, I go and see a generalist, and then I get referred to a specialist. And the further through the hospital system I go, the more specialist and expert the people I see will be. In this case, in the context of litigation, we've started off with a very learned and specialist first instance judge. Is he still here? And obviously a very eminent court of appeal. And then we end up in front of a very wise tribunal, although one wouldn't necessarily call them specialists in patent law. And I wondered whether Ursula and Edgar thought this was one of the strengths of our system.
Well, what do you...
doesn't go to be.
I mean, that's true in Holland too, isn't it?
Yes.
When you get to your Supreme Court, you have a lot of people who know nothing about patents by and large. You have an advocate general who does.
Yes. No, we have two judges who also did patent cases in lower courts, in the Supreme Court. So it's not like that it goes down with experience.
One of the first questions I asked when we had tea together, whether or not the Supreme Court judges have any experience in patent law.
I answered the question.
I think it's not that bad, but I would have wished that they included some thoughts about EPC 2000 claims, because only then I could judge whether or not this is a concept I could live with under the English law, of course. But
Yeah. Right, well, I reckon it's drinking time. So we adjourn to across the road, and it's either the north or the south cloisters. You can probably work out which it is where the drinks are. And if there are drinks in the north and the south, see which have got the better drinks. And thank you all for coming, and thank you very much, panel.